Hello everyone, welcome to Steno Aspirants. I am Akshay and I am going to dictate you Rajasthan High Court judgments containing 720 words at the speed of 90 words per minute. The dictation will fluctuate between the speed of 85 to 95 words per minute. So get ready. 3 seconds. Start. Learned counsel for the appellants relied upon the decisions of this Honorable Supreme Court in the cases of J.S. Parihar, Supra, Sudhir Vasudev, Chairman and MD ONGC and others versus M. George Ravi Sekran and others AIR 2014 SC 950 Thomson Press India Limited versus Nanak Builders and Investors Private Limited and others AIR 2013 SC 2389 Babulal and another versus Municipal Corporation Ratium and others 2005 13 SCC 101 Dinesh Kumar Gupta versus United India Insurance Company Limited and others 2010 12 SCC 770 and United Bank of India versus Satyavati Tandon and others 2010 8 SCC 110 stop. Per contra, learned counsel appearing for the respondents, petitioners would argue that the writ petitioners were prepared to repay the loan and despite specific offer made, the bank officers in connivance with land grabber hastily proceeded to put the property to auction after issuing notice and drawing the proceedings under sections 13(2) and 13(4) of the Surface Act, which was challenged by the writ petitioners by moving application before the DRT stop. However, the DRT was not regularly sitting and hearing the applications, and in the meantime, before petitioners' application for stay could come up for hearing before the DRT in order to frustrate their prayer for stay, the bank officials contemners issued sale notice and fixed 30/1/2018 as the date for auction stop. In these pressing circumstances and to save their immovable property from auction without hearing of the stay application by the DRT, the writ petitioners had to approach the writ court stop. It is further contended that taking into consideration the aforesaid peculiar circumstances, writ court passed an order on 25/1/2018 protecting the writ petitioners by issuing directions so that their application for stay is not rendered infructuous and they may not be deprived of their property till the application for stay is heard and decided stop. Learned counsel would submit that the writ court void its order dated 25/1/2018 did not completely stay the auction proceedings, but the protection was to the effect that the bank may proceed with the auction on 31/2018, but the sale would not be confirmed till the next date of hearing, with clear direction to the DRT to hear the stay application, and in case hearing on the stay application does not take place, then the order passed by the court to remain in force till hearing of the stay application stop. The order clearly intended to protect the writ petitioners till decision of stay application and the appellant's submission that the stay would continue only till hearing, even though no orders were passed, is completely absurd and was never intended by the court. Stop. Learned counsel would submit that the bank officials are not illiterate or rustic persons. Stop. It was very clear from the order of the court that the court intended that till application for stay is heard and decided, the protection will continue. Stop. The DRT did not decide the application for stay, though the case was listed, but orders on stay application were not passed. Stop. Thereafter, auction notice was issued fixing a new date of auction, even though application for stay was not heard and decided one way or the other. The bank officials contemners proceeded to confirm the sale as also issuing a sale certificate and delivering possession to auction purchaser, thereby completely frustrating order dated 25/1/2018 passed by the learned single judge. Stop. Learned counsel would next submit that observation for taking back possession of the immovable property of the writ petitioners is only a consequential order and not a supplemental order as such. Stop. It is contended that in view of the judgment of the Honorable Supreme Court in the case of Jehal Tanti and others, supra, the confirmation of sale, issuance of sale certificate, and handing over of possession of the immovable property to the auction purchaser are void ab initio. Stop. Therefore, consequential steps were required to be taken by the bank officials, which has been observed by the learned single judge while holding the contemners guilty of contempt of the court. Stop. Further submission of learned counsel for the respondent is that after having flouted the order of the court, the contemners cannot be heard. Stop. Over. Contemners, CONTEMNORS, flouted, FLOUTED, consequential, CONSEQUENTIAL. Stop. Over.